Hey everyone, and welcome to the video. This is your instructor, Dr. Bradshaw, and this is Business Law Chapter 7, talking about contract law. And this is meant to be just an introduction to the chapter. We're going to talk about a few things, but just wanted to kind of break the ice and introduce you to contract law, because whether you know it or not, you're probably involved in a contract. Anytime that you download an app, or you sign up for a service, or you buy a car, anything like that, you are signing up for some type of contract. And I don't know if you can see this. I'll hold it up to the camera. I don't know if you can read it or not. Yeah, there you can read it. Yeah, you can pause this video and read this real quick. And pause. And so, I'm going to go ahead and read this to you and talk about it. It says, I have read and agreed to the Verizon Wireless Customer Agreement and Verizon Privacy Policy, including settlement of disputes by arbitration instead of a jury trial, as well as the terms of my plan and any optional services I've agreed to purchase. So you may have heard about mandatory arbitration. I believe we've discussed it. But basically, I am waiving my right to a jury trial and saying that if I want to have any type of remedy for any harm or perceived harm caused by Verizon, then I've got to go to arbitration and have somebody figure things out for us. And once they make a decision, it's binding. And I recently upgraded my phone. I went from iPhone XR to an 11. We're basically handing them down to the kids. It's kind of where we're at. But yeah, as I was going through that process of upgrading, I realized, hey, this is a binding arbitration clause right here in my face, so I would save it to be able to show my students. And so let's dive into the chapter and talk about a few things about contracts. Once again, not intended to replace the reading. This is just an overview, and I hope you will go in and do the reading. So let's talk about a few concepts. I'm going to put my glasses on now. Generally don't wear them in videos because you can see the reflection, but it does help. And so consideration, in most cases, consideration needs to be not something monetary per se. It just needs to be something of value. Most contracts are enforceable only if each party gets consideration from the agreement. Consideration can be money, property, a promise, or some rights. For instance, when a music company sells studio equipment, the promised equipment is the consideration for the buyer. Seller's consideration is the money the buyer promises to pay for the equipment. And so consideration is something of value that puts a deal in motion. And so a lot of deals have consideration in place. Promissory estoppel. And so the doctrine of promissory estoppel allows aggrieved parties to pursue justice or fairness for the performance of a contract in court. And so we might have to have a promissory estoppel if some of application or some type of agreement or relationship exists. So its legal application may vary from state to state, but the basic elements include a legal relationship existed between the parties. Yeah, so we have a relationship of some type of binding agreement, and we might need some promissory estoppel in place if we've had some egregious act happen or something where we have felt we were wronged. A promise was made. There was reliance on a promise that caused one party to act before any real consideration was exchanged. As an example, let's say I call a vendor and say, I need 200 plates ready for a party 2 weeks from now, and I don't have my credit card ready, but you know who I am. You know I'm good for it. Get it ready. We'll take care of it. So you get all excited. You go out and buy all the food, all the things you need to make those 200 plates for my party next weekend, 2 weekends from now. The day before the party comes, I call and say, hey, I'm giving you 24 hours notice. I don't need the party anymore. It blew up. We don't need it. And then you say, well, hey, I've spent all this money preparing these 200 plates. I've got thousands of dollars tied up in this food cost now. I mean, what's up? I've got labor. I've got equipment. I've probably, you could say I've probably spent $2,000 or $3,000 getting this thing ready. And now you're telling me, no, this food's going to rot. I need to have somebody I can sell it to. So I relied on that promise. There was a reliance. Under our under our legal system, you have a actionable cause at that point where you can say damage was done. And even though we didn't exchange any real consideration, well, there was a reliance on that promise. A substantial and measured detriment occurred as a result of a failure to perform on the contract. And then lastly, an unconditional result or gross injustice resulted from the broken promise. So these are some things that a court would look at if there is some type of issue of justice or fairness comes up between two parties or two or more parties. So let's talk about capacity and legality. This is an important one. Minors have no capacity to contract. So if a minor goes and makes a purchase that requires a contract, that contract is void because they couldn't legally enter into it to begin with. So there's an example here of Mary is 16. She signs a long-term endorsement deal, well-known brand, compensated for several years. At 20, she decides she wants to take a better endorsement deal. So she tries to avoid the agreement on the grounds that it was made when she was a minor and she lacked the capacity at the time. Mary will not likely succeed in having her agreement voided as she passed the period of incapacity because she's already turned 18 at that point. So mental incapacity is another thing. A couple of examples. If somebody is has a mental health issue or cognitive defect, they can be said to be mentally incapable of legally entering into a contract. So check that out. Voluntary intoxication, drugs and alcohol. If somebody is doing things, entering into contracts under the influence, they may not legally be bound to that contract because of the condition they were in at the time. So legality is something that the courts explore, and they go through this process of identifying, was the contract done legally? Is it enforceable? Is there a issue that might create a capacity issue where the person was either not legally able to enter into a contract? And so these are considerations the court makes. So let's talk about breaches and remedies. So material breach, this is when a substantial breach has occurred. So as an example, the one I told about, the 200 plates, that's a material breach of a contract. Once you enter into a verbal agreement, even without consideration exchange, the other party is reliant on that agreement. We have a verbal contract at that point. And so canceling the 200 plates is a breach of contract. However, let's say that I call back and say, you know, I ordered 200 plates, but I'm only going to have 180 people show up. Well, you know, that it's subjective as to if that is considered a material minor breach. And that would have to be, decided by the courts as to how much of a breach that is. There could be a remedy in place for that, though. So this is what we're trying to find, an outcome that is fair and just for all parties involved. So let's talk about remedies real quick. Remedies are typically will be available if a breach of contract is found, and are typically monetary damages, restitution, rescission, reformation, and specific performance. So let's take that same example with the plates and say I paid in advance. I ordered 200 plates. You show up the day of, only 150 plates. And I'm like, well, I paid for 200. You showed up with 150. Not all my guests got fed, and I've already prepaid you. So what type of remedy can we find? And keep in mind that over 90% of issues are solved outside of the court. People don't like to go to court. It's expensive. It's time consuming. And going to court is problematic because not only are you having to pay legal fees and court fees and the time to do it, but the decision might not go in your favor. So even though you could be in the right, you could be 100% correct in your assessment of what's going on, the courts could still make decisions that are outside of your favor. So it's best if you can resolve this outside of the courts. And so one particular remedy would be a refund of 50 plates worth of money. Another would be some type of service exchange, like performance. How about you come back 2 weeks from now and bring 50 plates for another dinner party I'm going to have or something? Or if I have another 200 head party, why don't you give me 50 free on that next one? Some type of performance. I had something recently happen. This is a little different example, but I had ordered a pizza from Papa John's, and so I go to get the pizza, and normally I order on the app. I'll go in 20 minutes later, it's ready, boom. Well, I go in 20 minutes later, not ready. They told me, we're just about to put it in the oven. Usually when they put it in the oven, it's like 6 minutes, done. Well, I stepped away for 20 minutes. I came back 20 minutes later, wasn't ready, and I had to wait another probably 10 or 15 minutes. So we're talking like knocking on an hour at this point. Well, they could have done a number of remedies, but the remedy they came up with was, I'm going to just give you a free pizza next time you come in. I'm going to put it on your account, call, we'll give you a free pizza. And even though I didn't request a remedy, they made one available to me. And so 2-3 weeks goes by, I think, hey, I've got a free pizza on my account at Papa John's. So I called the store up and got a really nice response on the phone. Ordered my pizza, went and picked it up, no problem, and it was perfectly cooked and everything was great. So yeah, great remedy, great performance. And so you want to try to find ways to resolve conflicts within contracts in order to please all parties and avoid courts if you can. And so this kind of wraps up the introduction to the chapter. Please go back and read. Don't let this be a substitute for the reading, because you really get the nuance of the information from the reading. And I can't think of a better format than this OpenStax book to be able to get that reading in an approachable way, because the chapters are not long, and you can really dive into it and be able to retain that information in a better way. So if you do have any questions, please reach out to me. I'm happy to help. I look forward to talking to you, and you have a great rest of your week.